Hello friends, welcome to the Point. In this session, let's discuss about Chief Minister. In the parliamentary system of government provided by our constitution, the governor is said to be a nominal executive authority, that is de jure executive, and the Chief Minister is said to be the real executive, or we can also call it as de facto executive. So we can simply say that the governor is head of the state and the Chief Minister is head of the government. Appointment of Chief Minister. A constitution, it does not specify any procedure for the selection and appointment of our Chief Minister. So Article 164 says that the Chief Minister shall be appointed by the governor, and this does not imply that the governor is free to appoint anyone as Chief Minister. The governor has to appoint the leader of the majority party in the state legislative assembly as the Chief Minister. In case if no party has majority rule, and then the governor, he may exercise his personal discretion in the selection and appointment of the Chief Minister. In such a situation also, the governor usually appoints the leader of the largest party or a coalition in the assembly as Chief Minister and asks him to seek a vote of confidence in the House within 1 month. The governor, he may have to exercise his individual judgments in the selection and appointment of the Chief Minister. So when the Chief Minister in the office dies suddenly and there is no successor, and at that case, at the death of the Chief Minister, the ruling party usually elects a new leader and the governor has no choice. He has to appoint that person as a Chief Minister. The Constitution, it does not require that a person must prove his majority in the Legislative Assembly before he is appointed as a Chief Minister. The governor, he may first appoint the person as a Chief Minister and then ask the person to prove his majority in the Legislative Assembly within a reasonable period, and this is what has been done in number of cases. A person who is not a member of the state legislative assembly, he can also be appointed as a Chief Minister for 6 months, but within that 6 months, he should be elected to the state legislature. If he fails to be elected as a state legislature, then he ceases to be the Chief Minister. That is, he loses his position as a Chief Minister. According to the Constitution, the Chief Minister, he may be a member of any of the 2 houses of the state legislature, but usually the Chief Minister, he is selected from the lower house, that is Legislative Assembly. But on number of occasions, a member of the upper house, that is the Legislative Council, has also been appointed as a Chief Minister. Oath of Chief Minister. Before the Chief Minister enters his office, the governor, he administers him to take the oath of office and secrecy. In his oath of office, the Chief Minister swears that to bear true faith and allegiance to the Constitution of India, and to uphold the sovereignty and integrity of India, and to faithfully and conscientiously discharge the duties of his office, and to do right to all manner of people in accordance with the Constitution and the law, without fear or favour, affection or ill will. In his oath of secrecy, the Chief Minister swears that he will not directly or indirectly communicate, or he will reveal to any person about any matter that is brought under his consideration. Term and salary of Chief Minister. The term of the Chief Minister is not fixed, and he holds his office during the pleasure of the governor. And this does not mean that the governor can dismiss him at any time. The Chief Minister cannot be dismissed by the governor as long as he enjoys the majority support in the Legislative Assembly. But once if the Chief Minister loses his confidence in the Assembly, he must resign or the governor can dismiss him. The salary and allowances of the Chief Ministers, they are determined by the state legislature. In addition to the salary and allowances which are paid to a member of the state legislature, he gets a sumptuary allowance free accommodation, travelling allowance, medical facilities, and so on. Powers and functions of Chief Minister in relation to the Council of Ministers. The Governor, he appoints only those persons as ministers who are recommended by the Chief Minister. Chief Minister allocates and reshuffles the portfolios among the ministers. Chief Minister can ask any of the minister to resign or advise the Governor to dismiss him in case of difference of opinion. Chief Minister, he presides over the meetings of Council of Ministers and he influences its decisions. Chief Minister, he guides, directs and controls and coordinates the activities of all the ministers. He can bring about the collapse of the Council of Ministers by resigning from office. Since the Chief Minister is said to be the head of the Council of the Ministers, his resignation or death, it automatically dissolves the Council of Ministers. And this resignation or death of any other ministers, on the other hand, it merely creates a vacancy. But when it comes to the Chief Minister, it dissolves the complete position of Council of Ministers. Powers and functions of Chief Minister in relation to the Governor. The Chief Minister, he enjoys certain powers in relation to the Governor. The Chief Minister is said to be the principal channel of communication between the Governor and the Council of Ministers. And it is the duty of the Chief Minister to communicate to the Governor of the state regarding all the decisions taken by the Council of Ministers, which may be related to administration or state proposals for legislation. To furnish such information that relates to the administration of the affairs of the state and proposal of legislation as the Governor may call for. And if the Governor requires to submit the consideration of the Council of Ministers regarding any matter on which a decision has to be taken by a minister but which has not been considered by the Council. That means any decisions that is taken by a minister, if the Governor requires, he can submit for reconsideration to the Council of Ministers, which has not been considered by the Council of Ministers earlier. Chief Minister advises the Governor with regard to the appointment of important officials like Advocate General, Chairman and members of the State Public Service Commission and State Election Commissioner and so on. Powers and functions of Chief Minister in relation to state legislature. The Chief Minister, he enjoys certain powers as the leader of the House. He advises the Governor with regard to the summoning and proroguing of sessions of the state legislature. That is, the Chief Minister can advise the Governor to delay the session of the state legislature. Chief Minister, he can recommend the dissolution of the Legislative Assembly to the Governor at any time. And Chief Minister will announce the government policies on the floor of the House. Other powers and functions of Chief Minister. The Chief Minister also performs certain other functions like he is said to be the chairman of the State Planning Board. He acts as a vice chairman of the concerned zonal council by rotation, that is by holding office for a period of 1 year at a time. Chief Minister is said to be the member of Interstate Council and the National Development Council. Both the councils are headed by Prime Minister. Chief Minister is the chief spokesman of the state government and he is said to be the crisis manager in chief at the political level during the emergencies. As a leader of the state, Chief Minister meets various sections of the people and he receives the memoranda from them regarding their problems and so on. Chief Minister is said to be the political head of the services. For Chief Minister plays a very significant and highly crucial role in the state administration. However, the discretionary powers that are enjoyed by the Governor, it reduces to some extent the power, authority, influence, prestige and role of the Chief Minister in state administration. that is the discretionary powers which is enjoyed by the governor, it reduces the power of chief minister till some extent. Relationship of chief minister with the governor. According to Article 163, there shall be a council of ministers along with the chief minister as a head to aid and advise the governor on the exercise of his functions, except so far the governor is required to exercise his functions or any of his discretions. Article 164. The chief minister shall be appointed by the governor, and other ministers shall be appointed by the governor but on the advice of the chief minister. The chief minister, he holds his office during the pleasure of governor, and the council of ministers, they will be collectively responsible to the legislative assembly of the state. Article 167. It shall be the duty of chief ministers to communicate to the governor of the state regarding all the decisions of the council of ministers, that is relating to the administrating affairs and state proposals for legislation, and also to furnish all such informations that relates to administration of the affairs and state proposals for legislation as the governor may call for. If the governor requires to submit the consideration of the council of ministers in any matter on which a decision has been taken by a minister but which has been not considered by the council of ministers earlier. This is the relationship of chief minister with the governor. See you in the next session with some other interesting topic. Thank you.